Denaturalization is the process, a legal mechanism with significant consequences, by which the U.S. government can revoke citizenship. It's a serious action, reserved for specific circumstances. This revocation applies to someone who became American through naturalization, not birthright citizenship. It doesn't affect those born as U.S. citizens. It's been part of American law for well over a century, with roots stretching back to the early 20th century. It's rooted in the fundamental idea that citizenship is a privilege, a right based on honesty, adherence to the law, and genuine intent. If someone lied, deliberately concealed information, or hid crucial facts during the naturalization process to gain citizenship, the government reserves the right to take that citizenship away. This is to ensure the integrity of the naturalization system. Historically, denaturalization targeted extreme cases, instances where individuals had demonstrably deceived the government. A prime example includes former Nazi guards and collaborators who concealed their pasts to gain entry and citizenship in the United States. The denaturalization process is a civil proceeding, not a criminal one, meaning it focuses on legal status rather than criminal punishment. Because it's civil, the government's burden of proof is somewhat lower compared to a criminal trial, requiring clear, unequivocal, and convincing evidence. The Immigration and Nationality Act, or INA, outlines the specific grounds for denaturalization, with the primary reasons being fraud or willful misrepresentation of facts during the naturalization application. Hiding a significant criminal record, providing false information about one's identity, or any other deliberate attempt to deceive immigration officials can put one's citizenship at serious risk. The Department of Justice, through its various divisions, is typically the entity that initiates these denaturalization cases, and losing a denaturalization case means not just losing U.S. citizenship, but also potentially facing deportation from the country. For naturalized citizens, the possibility of denaturalization challenges the long-held belief that their citizenship status is just as secure and unassailable as that of individuals born within the United States. The recent push and increased focus to expand denaturalization efforts and investigations has understandably created anxiety and uncertainty among millions of naturalized immigrants and their families across the nation. It raises a fundamental question about the nature of citizenship. Is naturalized citizenship truly permanent and irrevocable, offering the same protections as birthright citizenship, or is it, in reality, more conditional and subject to government scrutiny than many previously thought? The Trump administration has made denaturalization a top priority, escalating efforts to scrutinize and revoke citizenship from those suspected of fraud. The administration frames this as a national security and public safety measure, aiming to remove individuals who concealed criminal histories or dangerous affiliations. It's also about upholding the integrity of the immigration system, sending a message that cheating the process has real consequences. This is more aggressive than past policies, moving from investigation to active prosecution. The administration began by reviewing hundreds of thousands of naturalized citizens' files, especially those with incomplete fingerprint records. Now, the goal is to accelerate and expand these efforts, making denaturalization a routine enforcement tool. With fewer political constraints in a second term, the administration is determined to follow through on its promises. Executive orders and departmental directives ensure agencies like the DOJ and DHS prioritize denaturalization. What was once rare is now becoming a standard part of immigration enforcement. The administration's strategy centers on massive data mining and investigations within federal agencies. Agents are reviewing hundreds of thousands of records, focusing on cases where fingerprint data was never properly checked. The goal: find discrepancies, like someone naturalized under one identity but with a criminal record under another. More resources, personnel, and technology have been dedicated to this effort, especially at USCIS and the DOJ. If red flags are found, cases move from investigation to litigation, with the DOJ filing civil lawsuits to strip citizenship. The scale is unprecedented. Thousands of cases are being targeted, making denaturalization a continuous process. This shift institutionalizes denaturalization, turning it from an exceptional measure into a systematic program. The implications for millions of naturalized citizens are profound. Who's at risk? The question looms large, casting a shadow of uncertainty over immigrant communities. The administration states its focus is on individuals who intentionally committed fraud during the naturalization process. They assert they are targeting those who gain citizenship through deceitful means, or deliberately hid critical information during naturalization. This includes omitting crucial details that could have affected their eligibility. The most obvious cases involve serious crimes, those that are clear violations of the law, like felonies that would have made someone ineligible for citizenship in the first place. These are the cases where the individual's past actions directly contradict the requirements for becoming a citizen. For example, Army veteran Elliot Duke faces denaturalization for concealing criminal convictions, a serious allegation with potentially life-altering consequences, showing the focus on public safety threats. The government emphasizes that these actions are necessary to protect the community, but the net is wider, much wider than many initially anticipated. Even minor misrepresentations, seemingly insignificant details, like using a false document decades ago or misstating marital status, events that occurred long in the past, can trigger a case, even if the mistake was unintentional. Critics worry that small, unintentional errors made perhaps out of confusion or misunderstanding could be used as grounds for denaturalization, potentially stripping individuals of their citizenship, creating fear among law-abiding citizens. This fear permeates communities, affecting families and individuals alike. The criteria can be broad, leaving room for interpretation and potential overreach, potentially including past associations with groups later deemed problematic, even if those associations were innocent at the time. Civil liberties advocates warn this could become politicized or discriminatory, leading to unfair targeting based on beliefs or affiliations. There's concern that people from certain countries or backgrounds, particularly those from politically sensitive regions, could be disproportionately targeted, facing selective prosecution and unfair scrutiny. The result, the ultimate consequence, a climate of uncertainty, a pervasive sense of unease and anxiety, where the security of citizenship depends on shifting government priorities, creating a precarious situation for naturalized citizens. For many, the fear is not just about what they did, the specific actions they took in the past, but about how their past might be reinterpreted, how past actions might be viewed through a different lens. The risk extends far beyond those with criminal records, encompassing a much wider range of individuals and situations. A recent Supreme Court decision has changed how immigration policies are challenged in court. As of June 2025, federal judges can no longer issue nationwide injunctions, orders that block a policy across the entire country. Now, judges can only grant relief to the specific plaintiffs before them. This means controversial policies like denaturalization or birthright citizenship changes can be enforced in some states even if blocked in others. The result is a patchwork of legal statuses with policies in effect in some places but not others. While this is a procedural win for the administration, it doesn't resolve the underlying legal battles. The fight over the constitutionality of these policies continues in the lower courts. The denaturalization plan has sparked fierce debate. Supporters say it protects national security and upholds the rule of law. Citizenship must be earned honestly and fraud should have consequences. They argue it targets real threats, like those with violent criminal pasts or terrorist ties, and preserves the integrity of the system. Critics counter that it creates a second-class citizenship, making naturalized Americans feel perpetually insecure. Legal experts warn it could punish minor, decades-old errors and disproportionately affect immigrants. Because these are civil cases, defendants lack some constitutional protections, like court-appointed attorneys. Opponents also argue the policy risks racial and ethnic bias, undermining equal protection. They see it as an erosion of the principle that citizenship, once granted, should be permanent. The debate is about more than law, it's about what it means to be American. The administration is also challenging birthright citizenship, a move that has sparked intense debate and legal scrutiny across the nation. This challenge represents a significant departure from established legal precedent, a core principle of American law, one that has been a cornerstone of our legal system for over a century. It's a principle deeply embedded in the fabric of American society. An executive order seeks to deny automatic citizenship, a directive that has ignited a firestorm of controversy and legal challenges. To U.S.-born children of undocumented immigrants, a particularly vulnerable population, or those on temporary visas, individuals who are legally present in the United States but not considered permanent residents. This challenges the 14th Amendment, a bedrock of civil rights in America, which has long been interpreted to grant citizenship to anyone born on U.S. soil, regardless of their parents' immigration status. This interpretation has been upheld by numerous court decisions over the years. Supporters argue that children of non-citizens aren't fully subject to U.S. jurisdiction, a claim that hinges on a narrow reading of the 14th Amendment's text. But most legal scholars disagree, citing historical context and established legal precedent. Saying only a constitutional amendment, a complex and arduous process, could fundamentally change this. The Supreme Court's ruling on injunctions and the varying interpretations across different jurisdictions means the policy could be enforced in some states but not others, creating a patchwork of citizenship laws across the country, creating legal chaos, a situation ripe with uncertainty and potential for abuse. A child could be a citizen in one state but not in another, depending on where they were born and where their parents reside, leading to confusion and inequality, undermining the very principles of equal protection under the law. This could result in stateless children, individuals without citizenship in any country, unable to access basic rights or services, leaving them in a legal limbo with limited opportunities. The policy is currently blocked, thanks to legal challenges and court injunctions. But the legal fight is ongoing, with the potential to reach the Supreme Court. The battle over birthright citizenship strikes at the heart of American identity, forcing us to confront fundamental questions about who we are as a nation. The outcome could reshape the meaning of citizenship for generations, impacting the lives of countless individuals and families for years to come. The human cost of denaturalization is immense. Millions of naturalized citizens now face anxiety about their status, fearing that even honest mistakes could threaten their lives in America. Denaturalization can tear families apart, parents deported, children left behind, and entire households thrown into turmoil. Legal battles are expensive and emotionally draining, often leaving families financially devastated. The fear extends to communities, making people less likely to engage with authorities or participate in civic life. This erodes trust in government and weakens the social fabric. Critics argue that aggressive denaturalization undermines the promise of American citizenship as a permanent bond. The policy forces a national conversation. Should there be different classes of citizens? The potential for widespread denaturalization could reshape the country's demographic and social landscape. The impact goes far beyond the courtroom, touching the daily lives of those who call America home. The future of American citizenship is at a crossroads. The DOJ will continue filing denaturalization lawsuits, especially in cases of serious crime or fraud, setting new legal precedents. The fight over birthright citizenship will return to the courts, with the Supreme Court likely to weigh in on its constitutionality. Congress may be pushed to clarify or change the laws, either strengthening denaturalization powers or protecting citizenship rights. The debate will shape whether citizenship remains secure for all or becomes more conditional for some. These battles force America to confront its identity as a nation of immigrants. The coming years will determine if citizenship is a permanent right or a privilege that can be revoked. The very soul of American citizenship hangs in the balance.